Good afternoon. My name is Michael Paris. I teach in the political science department here, and I'm the pre-law advisor for the college. Welcome to this interview talk with Professor Julie Suck of Fordham Law School. She's written this marvelous book, After Misogyny, How the Law Fails Women and What to Do About It. Before we talk about the book for just a second, as an introduction, I want to just say a few words about our pre-law legal studies program. If you're a student here, you're interested in law school, you would go to that URL, CUNY Commons GC, and you could subscribe to that, and then you'll get announcements in your inbox. You could also just email me directly at that information. Happy to talk with anyone. The Legal Studies Institute is a minor in legal studies and a set of co-curricular support structures and activities. We want to offer resources and opportunities for students interested in law and related fields. We also want to enhance the quality of the intellectual life here at the college, so this is part of that. We have academic talks and events. Put differently, we're interested in offering a shot at the American dream. That's what we do here at CSI. Every human being should have a chance at human flourishing, and this is how we do our part. We have a minor in legal studies. It's easy to complete. It's helpful if you want to go to law school. I do one-on-one pre-law advising for all CSI students and grads. We have workshops on the law school admissions test and test prep opportunities. We're going to have a weekend boot camp on the LSAT, April 25th and 26th. If you can save that weekend, it's a full weekend of LSAT instruction. It's a great introduction to the test. We talk about the law school admissions process, and we have grads usually return to talk about their careers in the law. We sponsor public lectures, and we also do internship placements. You can do internships for credit. We have a small number of funded internships now, so you would want to see me about any of that. This is Bob Scamardella. His law firm has helped support funded summer internships. Yolanda Rudick is here. She's a graduate of CSI and a friend of Bob Scamardella's. These are two graduates who have given back a lot to help us. Yolanda was head of the sex crimes unit at the Richmond County DA for a very long time. And this fund also supports reimbursements for law school expenses. So you could ask me about that as well. We also have a small endowment that gives us $5,000 to $6,000 a year for programming. That's Dan Kramer. He taught here for 40 years, and his widow has provided support to help us. And lots of thank yous for this event. The Student Pre-Law Club, Dave Pizzuto and his media team. He's up in the booth there. Carolyn Gianola helps us with the catering and the receptions, and she's amazing. Joe Cipoletti's our tech support guy here. Dana and Cheryl at the CSI Foundation been very helpful. And Professor Kathy Lavender, who directs the Women, Gender, and Sexuality program. Kathy, are you here? No, not yet. And is also director of our Women's Center. They're co-sponsoring this event. So, perfect. Let me just say a few. I'll do it from there. Okay, I'll talk about Let's hope it works. It will. Hello? Hello? Works beautifully. It's blinding light, isn't it? Look down, yeah. Find a spot. So we're here to talk about a book, After Misogyny, How the Law Fails Women and What to Do About It. I think it's fair to say that this book is a critique, maybe an indictment of the American way of law when it comes to gender-based inequalities in resources, power, status. It's a plea that we try to understand things a little differently, see things a little differently. A lot of comparative law in this book. It's wide-ranging, it's thought-provoking. It's deeply researched across space and time, and I guess I'm evangelical about this book. It's a great book, demands attention, but it's well worth it. So Professor Suck's interested in finding conceptual resources to help us rethink some fundamental issues with respect to feminism and the law. And her claim is, once patriarchy ends, once formal legal support for patriarchy ends, misogyny remains, it endures, and the law hasn't really addressed it properly in the United States. She defines misogyny in structural terms, or perhaps another way of putting this is there are baseline entitlements in law. There are things that are taken for granted that advantage men and disadvantage women, and we need to rethink these baseline entitlements. You've heard the phrase, maybe, racism without racist. Well, Professor Suck wants to talk about misogyny without misogynists. In other words, her definition is structural. So she writes, misogyny is the set of practices that keep women down in order to keep everyone and everything else up. Later, misogyny is most pervasive when it involves no hatred or violence against women. It is quotidian. So what are the underlying unnoticed baseline entitlements? What does this mean? The book has two key concepts that run throughout, and Professor Sucks calls these over-entitlement and over-empowerment, and we're gonna get into that a little bit in a few minutes. What are the issues here? What are we talking about? How should we think about abortion bans and reproductive freedom more generally? How should we understand the continued gendered division of labor when it comes to work and family? What is the significance and what to do about sexual violence, rape, domestic abuse, sexual harassment, and so forth? What about the overrepresentation of men and the underrepresentation of women in the halls of power, whether that's government or the corporate sector? And finally, this is a subject that I care a lot about, is thinking about the relationship between law on one hand and politics, culture, society on the other. Professor Suck shows in detail how specific legal frames and broader legal discourses constitute particular cultures of argument, interacting with politics and society in complex ways over time. As one scholar put it, ideas embodied in law will often do much to shape the language of politics, thereby contributing to the association of what is possible with the authority of the state. And we might say also that some ways of arguing and speaking and acting within law are more conducive to compromise, perhaps even conciliation, compared to other ways of speaking and acting. And if you read this book, you'll realize how this is so. The book is deeply researched. It digs deeply into different times and places to explore new possibilities, lots of comparative inquiry. We spend a lot of time in France, a lot of time in Germany, some time in Sweden, some time in Ireland, some time in Iceland. I mean, it's really evocative. I often had this sort of, wait, what, that can't be right, reaction to the introduction of a claim, and then, I'm sorry, I was then engaged and persuaded and encouraged to think. I can't remember a book that taught so much. I learned a great deal. And thank you so much for being here. It's really nice of you to join us here in an outer borough to talk about your book.
Thank you so much for having me. I'm really thrilled to be here this evening.
That's great. Okay, so let's dive right in. I'd like to begin by paraphrasing the great historian E.H. Carr, who said, before you read the history, read about the historian. So I want to, and there's a lot of history in this book. Before we start, could you tell us just a little bit about yourself, where you're from, education, how you arrived at being a professor at Fordham Law School?
Sure. So I was born in Seoul, South Korea, and at the age of 4, my family immigrated, and so we arrived in Queens in 1979. So I guess now you know how old I am. But so we moved to a place called Hollis. I became American in the birthplace of Queens hip-hop, Run DMC. And we lived there for a year. And then my parents, in pursuit of the American dream, thought that we should check out the middle of America. So we moved to Youngstown, Ohio. And it was an interesting time to be in Youngstown, Ohio. I think U.S. Steel had laid off a bunch of people. It wasn't the most immigrant-friendly place, especially compared to Queens. So we came right back. And then I grew up in a place in Queens called Bellerose. I don't know if any of you know it, but in Bellerose, I mean, it was just like an idyllic place where, you know, life revolved around a baseball diamond. I played softball, I played the violin, did everything. And so I grew up here in New York, and then eventually I went to college at Harvard, and I was interested in political theory. I was interested in democracy. I had vague ideas, although they weren't, I needed to learn my way because I had vague ideas that when my family immigrated, it wasn't the reason we immigrated, but when we immigrated, there was a military dictatorship in South Korea, and it was the height of the Cold War. And I think the Cold War confused a lot of our understandings of what is a democracy, and what is the relationship of democracy to socialism and capitalism. And these are things that I had some vague sense of growing up, especially because, you know, the ideological rift in Korea, because of North Korea, was so strong and strongly felt, and people had, on the one hand, strong opinions, but a lot of silence, not a lot of discussion, because it was so fraught. So, and I think those things deepened the curiosity that I developed, particularly when I went to college, because I was interested in studying political theory. I also had a love of just literature and culture. And so one of the things I ended up studying a lot of was actually French and French literature and French social and political theory in college. And this ends up becoming important because eventually I was very interested in law and politics. And so when I went to law school, my first year of law school, the Supreme Court decided Bush v. Gore, and this was considered unprecedented in democracy. The notion, I mean, just I'm oversimplifying, but the idea that the Supreme Court is going to decide the presidential election in the greatest democracy in the world, just to put it in somewhat stark terms. And so one of the things that I think we were focused on, whether or not, like, what's going on with American constitutional democracy, on the one hand. On the other hand, a lot of folks, a lot of my mentors said, this is a really good time to know something about what goes on in the rest of the world. And I had spent a lot of time becoming fluent in French, and I had spent a few years, I did my doctorate in political science, studying political theory in England. So as a student of law, I was always approaching American law with these lenses that were just faced at ideas that developed outside the United States. And I think that is very important for just bringing us to where I landed. I clerked on the DC circuit after law school, but after that, I started writing a bunch of articles in legal scholarship. But it was many of my articles about equality, democracy, anti-discrimination law were really shaped by understanding the development of public law outside the United States, and and I think that some of the things I noticed about U.S. law were really shaped by that experience and that academic trajectory.
And law school was, I'll say it if you won't, Yale, and a long stint on the faculty at Cardozo Law School.
Yes, I taught there for 13 years.
Brief stint at the CUNY Grad Center as a dean, and then more recently, Fordham Law School.
Yes.
Right. Well, yeah, anything can matter, right? Like, it just sort of, I'm humbled because in 1979, I think I was 20-ish, so. I hate young people when they're so productive and successful, you know? It's just terrible. You published a book, and we had you on a Zoom call to talk about it. It's a very different book, 2019 book on the history of the Equal Rights Amendment. And I just want to ask you briefly, like, that's a very different book. It was for kind of a popular audience. This is a work of scholarship. And it's, anyone can read it and benefit from it, but it's primarily for a scholarly audience. How do you see the relationship between these two books? They're very different, if you agree with that characterization.
So it is. I think this was written, this grew out of scholarship that I had been thinking of for a long time. In fact, I was probably writing this book before I wrote the ERA book, and I was working on one of the very interesting things that I observed while I was in law school and then as a young legal scholar was constitutional amendments in France, Germany, Italy in the 90s and the early 2000s, which I talk about in chapter 5 of this book, that paved the way for gender quotas. So laws that require gender balance in some political party lists for elections, as well as corporate boards. That was fascinating that there was a problem, like, could you really do that consistent with a constitutional commitment to equality? And there were amendments that were passed in the 90s and early 2000s that paved the way to make it clear that the constitutions in these countries would allow for affirmative action or gender quotas. And so that was fascinating to me because then, number one, they were doing these affirmative action amendments on top of gender equality clauses that they'd had since like World War II, if not earlier than that. And it really raised the question for me, and it was a question that we never talked about when I was in law school. By the time I was in law school, the ERA was long dead. No one talked about the Equal Rights Amendment anymore, and we didn't talk about its history. Although I had a vague sense that it had been introduced and failed in the United States. So having this comparative perspective of gender equality in the Constitution is a normal part of constitutions in every country, just like a free speech clause or something. But why had it been so difficult and why had it failed in the United States? And so that's how I started researching the ERA, largely for a larger comparative law project. But then that book, We the Women, grew out of some states, in a very bizarre and legally fascinating move, started to ratify the ERA like 35 to 40 years after the initial deadline. And then it raised questions about whether or not a deadline was legal. That's a super interesting question in constitutional law. So there were a lot of interesting technical questions, but I also noticed that it was like people outside of the law school context were most excited about the ERA. People in state legislatures, young people. There were movements of high school kids who created these groups to work on ERA, super late ERA ratification. So I really wrote that book for them, just trying to give them a legislative history that I thought could, in the, I guess I hate to say, unlikely event that the ERA does get added to the US Constitution, I think it is important for us to understand the way that its meaning evolved through the women who fought for it across multiple generations at this point.
Right. I mean, it could be added if the Democratic Party wins some elections, sequences of elections. It's possible.
Yes.
Yes. So I want to get into the book. I'm going to try to do a flyover of the argument, almost chapter by chapter. This isn't going to work. We're going to have to just focus on some examples and illustrations of the work. There's a lot of detail. It's very rich. So we're going to have to be glossy about some of this, but I do want to talk about Chapter 1, which is a review and critique of the American law of sex discrimination. And this begins, and I think this is little known, that Professor Suck starts with and comes back to from time to time, Ruth Bader Ginsburg and a sojourn in Sweden in the early 60s. So could you tell us a little bit about that, why you begin there, and then maybe we can jump through sort of some of the highlights of equal protection jurisprudence, which is gone over in the chapter.
Great. So in some ways, if you think of Ruth Bader Ginsburg as perhaps the most important intellectual foremother of sex equality law and sex equality constitutional law in the United States, and the way that the Swedish debates and changes in Swedish law and policy around gender roles shaped her thinking about what it was. What's fascinating is that the Swedish influence is completely accidental, but it's also an accident of misogyny itself. Specifically, Ruth Bader Ginsburg ends up in Sweden in the early 1960s when this whole debate about gender roles is raging in Sweden. because despite the fact that she was just one of the best law students ever, she couldn't get a job clerking for judges, or she couldn't get it was explicit. The Supreme Court justices weren't going to hire a female clerk, no matter how brilliant. And she was rejected from a lot of law firms. So one of the first jobs she takes is working in academia, not yet as a professor, but as a research assistant. And she's not the one who's choosing the project. She's working for a professor who is writing a book about civil procedure in Sweden, of all topics. And because she's working on that book, not a topic of her own choosing, she ends up learning the Swedish language and going to Sweden to research the book. And in Sweden, they're having this debate. There had been a report to the United Nations about gender roles. And one of the most important insights, Eva Moberg, who's one of the writers, who's writing in the newspapers that she's reading while she's in Sweden, really looks at the idea that women are expected to do all the child rearing. And even in a world where now gender roles are changing and now women can have jobs and be in the public sphere, the expectation, though, that even though women have full-time jobs, the expectation that they also bear children and raise children is not shifting. And in Sweden, they're casting doubt on that. And then politicians are also saying, and isn't it also a deprivation of men's rights to kind of funnel men into the role of being provider and participant in the economy without giving them an opportunity to flourish as caregivers and as fathers, right? So that kind of gender role debate is something that's very pronounced and very explicit in Sweden. And I think this is why, for Ruth Bader Ginsburg, I feel like one of her most important contributions to the law of sex discrimination is that if you have laws that are based on stereotypes about men and women, based on traditional gender roles that were enforced by patriarchal legal system, to her, that is sex discrimination. Stereotypes based on gender roles in patriarchal legal systems. And I think that's something that then everything she learns in Sweden, and then the way that she kind of reads also equality and racial equality in American understandings of the Equal Protection Clause, all of that goes into her brief in Reed versus Reed, which is an incredibly important brief for bringing the Supreme Court to a point where they're starting to read sex discrimination as a problem for the Equal Protection Clause in their cases as they get litigated throughout the 1970s. And many of those cases, Ruth Bader Ginsburg litigates herself, developing this theory. And that's how we end up with the law of equal protection, leading to heightened scrutiny for any form of sex discrimination in the law.
Okay, thanks. And this law is, academics call this formal legal equality. So what it means to treat women equally is to treat them the same as, based on characteristics that are not using sex as a proxy for something else. Reed uses sex as a proxy for ability to administer an estate. The military and Social Security Administration make assumptions about men and women and their roles when they allocate benefits, right? And a lot of the plaintiffs in her cases were men, which Professor Suck notes. And I guess that, we should at least mention there's a kind of a culminating moment for this paradigm of equality in the VMI case, and here Ginsburg writes as a justice, the Virginia Military Institute case. So could you say a brief word about that, and is it a victory for feminism?
So I think the complication is that even though the notion that the law should treat men and women the same, formal equality, is often attributed to Ruth Bader Ginsburg's work, I think she had a more nuanced understanding of what should actually happen. And I think she was always trying to thread a needle because, on the one hand, at many moments, treating men and women the same is the best way of eradicating the stereotypes that are holdovers from a patriarchal legal system. But she also understood that sometimes you actually needed to treat men and women differently, in order to overcome the disadvantages that women faced because they were mothers and because of patriarchy, because of past sex discrimination. And I think the challenge for her when she decided, or when she wrote the Supreme Court's majority opinion in United States versus Virginia, was that she wanted to strike down, so that this is a public institution, a military institute in Virginia that only admitted men. They excluded women from what was a very high quality, prestigious military education in Virginia. So they're writing opinion saying that's unconstitutional, and the way that they get there is by saying any laws that treat men and women differently should be scrutinized and should only be permitted if there is an exceedingly persuasive justification. The needle that she is threading is she is not saying they should always be struck down on strict scrutiny when there's a compelling state justification. So in constitutional jurisprudence, this is important. And I say that she's threading a needle because 1996 is an extremely important moment for the Supreme Court's race equality jurisprudence. In 1995, the Supreme Court decides a case called Adirond, and I would say it's probably the most significant pivot point or it's a turn that the Supreme Court takes that pretty much takes us to 2023, the Supreme Court's case striking down race-based affirmative action at Harvard and in public institutions of higher education. So the Supreme Court takes a turn in 1995 that says formal equality, treat color blindness, race blindness, and you need a compelling governmental interest to overcome color blindness. And that sort of leads the Supreme Court on like a 30-year path to destroy everything that the government might do to remedy societal racial discrimination, which can be significant. VMI, Justice Ginsburg is trying to write the opinion to recognize that sometimes you might need to treat men and women differently in order to compensate the economic disadvantages that women have suffered, and also to leave room for the governmental interest in remedying societal sex discrimination. As of 1995, the Supreme Court has said that remedying societal race discrimination is not compelling under the strict scrutiny framework. And I tell this story because, I think there are a lot of ins and outs with the doctrine. I think Ruth Bader Ginsburg was very practical in that she had a very nuanced view of formal equality being probably the best presumption for getting rid of those patriarchal stereotypes, but she also understood that that could be incredibly rigid and could kind of work across purposes if you were actually pursuing gender justice or trying to actually undo the disadvantages of patriarchy, in the same way that there's an analogous problem in the race context, that generally color blindness, you need that to desegregate and to get rid of Jim Crow, but if you're too race blind, you'll never actually be able to deal with a whole history of racism against certain groups.
Right. So this is a little more nuanced. I mean, because you have these comments about how this jurisprudence lives in some unintended, counterproductive, arguably, ways. I'm quoting, the jurisprudence that Ginsburg spawned became a weapon of misogynists in the 21st century, and later, you write, U.S. equality law protects misogyny as well as feminism. So you don't want to lay this at her feet. She was well aware of it, but there's a problem that you want to highlight. Could you talk about that? Like what later at the end of the chapter really is what I'm talking about.
Yeah, I think the real problem is the limited ability of courts and judges to actually dismantle patriarchy as a legal system. Because if you think of patriarchy as a legal system, and I spend some time laying out what I mean by that, but if the idea is that men have rights and women don't have rights, and the reason women don't have rights is that the women are supposed to be the society's plan for social and biological reproduction. Because every society wants to reproduce itself to survive ad infinitum. And so if women are the plan for transgenerational reproduction, then they need to be kind of coerced into bearing children and raising children. And that's the justification within patriarchal legal systems as to why only the men have rights, only the men are participants in economic and political life. And so if you think of patriarchy as a legal system as what I've just described, one way that you can try to shift from patriarchy to, let's say, egalitarian democracy is by saying, okay, now women also have rights. But the problem with saying, okay, women also have rights is that it actually does not replace the infrastructure of reproduction that women not having rights was, but the society still aspires not to expire tomorrow. Meaning, so now if you're just saying women also have rights, but our plan for social reproduction, biological reproduction, has now fallen away. Women cannot be coerced to bear children or to raise children. They have choices. They can do market work. Once you no longer have that infrastructure, then what I call misogyny takes over. So even though women have rights, then the people find ways of enforcing the expectation that women continue to bear children and raise children, even if we don't have a patriarchal legal order. And so you could see that as, the law of sexual assault insufficiently protects women against sexual assault. That's a form of coercion. Laws banning abortion, so it does not allow women to choose to escape from the obligation to at least bear, if not also raise a child, right? So that's what I'm calling misogyny, even after we're trying to transition away from a patriarchal legal order. And so when I say, so I think the problem is that Ruth Bader Ginsburg was fundamentally a lawyer and then a judge. So her understanding was one piece of how do we dismantle patriarchy. Women now have rights. They have equal rights. But another huge piece of it is then we need a gender equal infrastructure for making sure that there's childbearing and child rearing if the society is going to survive. For Ginsburg, in Sweden, the gender roles debate was that. But in Sweden, it didn't translate into bringing lawsuits against laws that discriminated against women. They weren't doing a lot of that. Their idea that men and women should share equally in both public life and in family life, they gave effect to that by building child care centers and by having parental leave, funded public policies of parental leave for both men and women. And those are not the kinds of things you can achieve by litigation. You could strike down laws that are based on stereotypes, but you can't strike up a child care center if you're a judge.
Yeah, I see. Right, so half of the Swedish agenda came over with her, and you say at the end of the chapter the other half didn't get developed here.
Right.
So,
and then the half
so now
that
you have
did
now
come,
you have two jobs.
Right.
So yeah. So
and then the half that did come, which got translated into gender blindness, formal equality. And I think that could be weaponized and has been weaponized to kill off affirmative action for women, gender quotas.
Talk about that for a second,
Yeah.
because I just can't let this go. We're still on chapter 1, by the way.
Yes, sorry.
So maybe we won't get through the whole book. But I can't let this go without very arresting pages in chapter 1 about the National Coalition for Men, a case called Woods v. Horton that people don't know about. And
it's a state intermediate appellate court case.
So if you can just talk about the turning of the doctrine back against women for just a second.
Yeah, well, in California, state constitutional law in California took a slightly different turn from federal constitutional law in that they decided to strictly scrutinize, as opposed to intermediate scrutiny, any kind of laws or public policies that treated men and women differently. And so the outcome of that was that under California state equal protection analysis, if you had like a state policy or you gave public funding at the state level to a domestic violence shelter that was for women survivors of domestic violence and their children, the children could be of any gender. but the funding, there were domestic violence shelters that were getting public funding that said we are only for female domestic violence survivors. And that was challenged, saying you can't give public funding to that because you have to strictly scrutinize anything that the government's doing that treats men and women differently. And I think it was a man who had been excluded from a publicly funded domestic violence shelter. He claimed that he was also a victim of domestic violence who challenged that. And I think under this analysis that really emphasized gender blindness and strictly scrutinized any form of sex distinction in public policy or the way that the government treated its citizens, the outcome was that you couldn't have domestic violence shelters that only awarded places to women who were survivors of domestic violence. And that's one of many examples where I think governmental actors and public policy, they try to, and you could, maybe affirmative action is the shorthand that we should use for it, but they try to make distinctions between women and men based on either disadvantages or likelihood of need of more resources, very connected to the position of women because of a past of a patriarchal legal order. And I think you can see domestic violence as that kind of problem. There are many examples like this in that chapter 1 where I think efforts to distinguish between men and women for the purposes of overcoming patriarchal disadvantage have been struck down or questioned in litigation because of the assumption that a commitment to gender equality must involve a commitment to gender blindness. A more recent example than the Woods case is the litigation a few years ago against California had passed a bunch of laws requiring every corporation in California to have at least one, not an equal number, just one, at least one female member of the board on a corporate board. And that too, under California strict scrutiny, equal protection analysis was struck down by some of the California courts.
Yeah, it's fascinating kind of turn of events, right? And the way it runs on a parallel track with race is also quite interesting. Mm-hmm. Would lead you to elections and controlling the government for a while as a solution, I think. Chapter 2, I just want to ask you to talk briefly about these concepts of over-entitlement and over-empowerment. They're normative terms. Entitlement is not over and empowerment is not over unless it's unjust, and Professor Suck makes the argument that it is. But if you could just talk about those two concepts, and I think we're going to skip this chapter. There's fascinating discussions of some other legal concepts and categories in it, but I want to get to abortion and reproductive freedom, before we wind up here. And that's going to be a longer conversation.
So these are two concepts that I actually develop by looking at familiar legal concepts mostly outside the United States, although they exist in the US as well. So over-entitlement, I think, tracks the idea of an unjust enrichment. So unjust enrichment will be when someone gets all these benefits at someone else's expense, and that's different from someone actually wronging or injuring another person. They get these benefits at someone else's expense. If that happens, the person whose expense those benefits have been at can bring a lawsuit claiming an unjust enrichment. And I think it's a useful concept for understanding that in addition to discrimination against women, the problem with patriarchy is not just that they treat women and men differently, but that they unjustly enrich society at women's expense, meaning there's an expectation that women bear and raise children for which they are not compensated. That's not only for the women to privately benefit, but the bearing and raising of children is to the public and social benefit, but it's uncompensated. And so that's the idea of over-entitlement. Over-empowerment, really, to get into it, I look at another doctrine that exists primarily outside the United States, and not just in public law, in many areas of law, abuse of right doctrine. And the abuse of right doctrine is very interesting because it says even if you have the right to do something and the law recognizes your right to do something, sometimes you could recover in tort law or, if you have the right to do something, you have the right to property, for example, but if you exercise it in a way that shows complete disregard for the interests of others, sometimes courts and the law and the legal doctrine will say that you've abused the right. So even without saying that you don't have the right to do it, the concept of abuse of right. And that's an important one also for understanding the power imbalance in patriarchal legal systems, or even the power imbalance in equal democracies where we might say because someone is elected, they can do everything that's within that elected office, say the president's power. And so if the president has discretion to do things, for example, as commander-in-chief, you could say the president has obvious power under the Constitution to act as commander-in-chief, just to take a contemporary example, right? You could say conceptually, is it possible to abuse your power as commander-in-chief or not? One answer might be the fact that you have that power in the Constitution ends the conversation. You have that power, so it doesn't, once you have discretion, there's no concept of abuse, right? But in many European legal systems, there's this added layer. Even if you have that power, even if you were elected, even if you have the power to do something, sometimes the law will recognize that you've used it in a way that's so showing blatant disregard for the interests of others and the interests of the public that we're not going to allow it. And I think there we can think about many things that we liberals might think of in society as not necessarily sex discrimination, but men and people who hold power, doesn't always have to be men, using it in a way that actually seriously disadvantages and shows lack of respect for the people who do caregiving work and invisible work that actually keeps the society going.
Yeah, and is a contemporary example because the case law that Professor Suck talks about when she talks about abusive right, it's people who are just doing what they're allowed to do, but out of spite or a desire for revenge or to torture other people for the pleasure of it. So it's very interesting conceptual development. All right, so let's turn to abortion and reproductive justice. And I think maybe, I don't know, let's see how we do. I want to start with a quote. I mean, I found this chapter really evocative, provocative. It's about legal discourses and legal framing and how to think about the value of an unborn life, the value of a woman's life. Just a fascinating treatment. So here's the quote. The real misogyny involved in banning abortion is governmental underreach, not governmental overreach. I'll read that again. The real misogyny involved in banning abortion is governmental underreach, not governmental overreach. So if you want to talk about what that means, or maybe you could start with your basic take on Roe v. Wade and what you call the privacy-poverty compromise. Just start us off on this topic, this fraught topic.
Yeah, so I think that this chapter was really written in response to, and this isn't original to me, I think feminists have grappled with, if there is something wrong with banning abortion, what is the problem? And the US constitutional law response, the way that it was framed in Roe v. Wade, is that it violated a right to privacy. And as you know, Dobbs overruled that because the right to privacy is not explicitly enumerated in the Constitution. It was found in the Due Process Clause of the 14th Amendment. And so the discomfort with finding a right that's not enumerated, but at least the idea now that it violates the due process-based privacy right. In the United States, it was always, the problem is that it's none of the government's business. The business of childbearing and child-rearing is none of the government's business. And it's very powerful rhetoric. The last person you want deciding what to do about your body is the government, right? And I guess what I'm trying to say when I call this, when I say the problem is governmental underreach, is that I think that much of our thinking about what's wrong with banning abortion is premised on the notion that the government has no interest in what happens to your body, but not just what happens to your body, but has no interest in bearing and raising children. And I think that is borne out in the way that we think about parental autonomy. It's very different from many other countries where it's understood. And this is where I think the over-entitlement, unjust enrichment frame can be helpful, that the government does have an interest because when people do decide to have children or choose to have children, or worse, when some women are coerced by men who rape them, and they have no choice because the state bans abortion, if they have to then raise children, the notion that it's really none of the government's business what happens doesn't really make sense because children are raised often through, especially in patriarchy, women are coerced into bearing and raising children. So the main theoretical premise of that chapter is that childbearing and child rearing necessarily involve the state. That the state has an interest in it, the state is unjustly enriched by it, society is unjustly enriched by it, the men who control the economy and the state are unjustly enriched by it, and therefore what happens when you ban abortion is that the coercion, like women are coerced into bearing children without being compensated. And without being properly recognized for the invisible labor that they perform. And I think one response to it might be then the government should not do that. But I think another set of responses that I think are worth exploring are that in societies, and not all of them, but in some societies that restrict abortion more than ours do, there is actually much more support for motherhood and childcare than you see in places that think that the decision to bear and raise children is really none of the government's business.
Yeah, so the chapter takes us through the evolution of law and policy and constitutional politics, really, in several other countries. And it's counterintuitive because you start out in these countries that are talking about honoring motherhood or being pro-life in that sense, and then the evolutions surprise. You know, some of these places have as robust or more robust protection for terminating an unwanted pregnancy now after decades of struggle, starting from a different frame. So the paradox is, how does pro-life constitutional country end up with pro-choice results 30 and 40, 50 years down the road compared to the United States? And, you know, Germany is a key example. Ireland, of all places, right? There's a number of pages on Ireland and abortion. So, you know, we can't do the details, but this is just really rattles your cage because the discourse is more about taking various perspectives and interest into account, and I would say balancing is a term we use, as opposed to very strident sort of all or nothing privacy discourse in the United States. And, you know, you say some rather provocative things in the chapter. So why don't you, if you could talk about that, and then I think I want to maybe challenge you a little bit just for play devil's advocate a little. So
yeah.
we just put it that way.
So I think in the United States,
that's a cop-out, right? Go ahead.
In the United States, one of the things that Roe did was, I think, it created a very polarized politics of backlash. that I think you don't see in a lot of other countries. And the Irish example is really interesting because, on the one hand, partly in reaction and fear of Roe in Ireland, they passed a draconian constitutional amendment in 1983 that put in the Constitution protection of the unborn life of the fetus. And so it was like a constitutional matter that abortion was criminalized in Ireland from 1983 until they repealed it in 2018. But what I'm saying is that once you say, like, my body, my choice, no matter what, abortion on demand, just to give like the exaggerated account of what Roe and what pro-choice politics is about, the backlash that you get is, well, that's an absurd position, you know. And I think, and I think that the reality of most people, even people who are getting abortions and want to have that choice for themselves, the reality is that it's complicated. And very often, women who are getting abortions are not choosing an abortion like, I feel like getting an abortion today, just like I felt like getting vanilla as opposed to chocolate ice cream yesterday. It is an important life choice that has to do with the burdens of motherhood, balanced against other choices one makes that are meaningful, that give your life meaning. And if that's true, then I think that in Ireland, the way they end up going from 1983, criminalizing abortion in the Constitution, to 2018, a referendum repealing that, is through citizens' assemblies. People from all walks of life in Ireland get together and deliberate on the abortion question. I think this is also borne out if you look at work done by political scientists and sociologists about pro-life and pro-choice attitudes in the United States as well. Most people are kind of in the middle, in that they don't think that you should just choose abortion lightly. They understand that there are reasons people choose abortion, and those reasons should be taken seriously, and maybe law has a role to play in structuring those choices. And this is just a kind of long-winded way of saying that I think that the model that's taken hold in a lot of other countries, but not here because of the polarization, is one where generally abortion is available. We could call it on demand, but the idea is that within the first trimester, there's great deference to the woman's choice. That doesn't mean she's always making a good choice. It just means that the state doesn't find out or question the reasons for the choice. She could get the abortion with great deference to her choice. But then after the first trimester, there's what's known as an indications model. And the indications model in many other countries is there are abortions, but there's some kind of process that's not totally private by which the reasons for the abortion, often life or health of the pregnant person, those are the indications that lead to a legal abortion. What's really interesting is that after Roe was overruled by Dobbs, in the United States, we're not seeing the indications model. We're seeing just really draconian, only to save the life of the pregnant person, life of the pregnant woman, whereas in a lot of other countries, life or health has included because of decisions made by courts, social understandings of mental health reasons for having an abortion, social reasons why an abortion might be legally justified, even if there's no imminent physical threat posed by the pregnancy. And I think that having that model, the way it actually works in practice is that most people who want an abortion can get one at various stages of the pregnancy, but the way that we describe it in our symbolic politics is not abortion on demand. The way that it's described is the life of the unborn is important. The autonomy of the woman is also important. We're going to have a framework that largely defers to the woman's choice, but with an understanding that there is a public interest in preserving and taking care of not only unborn life, but born life. When people have children, there's going to be paid parental leave. That's what it means to actually be really pro-life. You have paid parental leave and childcare, so that often, as one of the main reasons, economic burdens of motherhood falls away as a reason a person would actually, in fact, need to choose an abortion.
Yeah, and if I just borrowing your words, the chapter does make you think about something. This is how you put it: is let's think more deeply about the conditions of choice, and not simply choice, right? Like, how does that look? What are the array of incentives or opportunities or issues that someone with an unplanned or unwanted pregnancy may be confronting? I want to read one more quote, and I don't know. Should I? I don't know whether to challenge you or not. I don't really want to. Yeah, so near the end of this chapter, you write, keeping abortion safe and legal in America will require engaging people who want the law to protect unborn life and save women from life-ruining pregnancies, but who feel moral discomfort with abortion on demand. And the question would be, well, are the people who want to ban abortion, are they in good faith? Maybe in Ireland and Germany they were. I'm not seeing that here. I'm seeing people talking about a culture of life, and women are bleeding out in the parking lot, right? I know you wouldn't deny that, but is that framework of, the joint opinion in Casey had some rhetorical shifts that were like this, right? On the one hand, on the other hand. But, stand up, fight, disrupt, they're in bad faith. They want to keep women and sexual minorities in their place. They don't really care about all life. They care about going back to patriarchy. And I guess this would be a question of what are the strategic pros and cons of a more confrontational approach, I guess, right? So if you want to address that, you can just...
Yeah, so I think one of the difficult things about this book, and I could say a little bit about where the work in this book has taken me, I think you're absolutely right that there's a kind of polarization in American politics. And some people think that the polarization, we could have a longer debate about what the historical causes were. I think Ruth Bader Ginsburg also once said that she thought that because Roe was probably the thing that really triggered the growth of the pro-life movement and its political strength and its funding that we see today. That before, arguably, and I think Ginsburg said this in a lecture sometime in the 1990s, that before Roe, state legislatures were kind of moving towards, even though they had abortion bans, allowing abortions when mental health indicated it. That's pretty significant. That they were evolving. A lot of states were evolving through the democratic process, but Roe just basically moved them to a certain point because the court said there's a constitutional right now, so you can't have something a little bit more incremental. And so then you get this kind of like courts pronouncing a right, and then people on the far right, the religious right, mobilizing and funding and I don't know, I wouldn't blame the court protecting rights for the polarization that we get, but I do think that we need to focus on both the sources and the way out of this polarized politics in the United States, because I think you're right that if you just have people who are unable to compromise and even act in good faith, then it, nothing that I'm saying in this book about what's going on in other countries is going to look particularly realistic or attractive in the United States. And that's why I think a lot of my work is now focused not just on substantively what should our law or policies be, which, you could describe this book as a little bit, but I'm much more interested now in, well, how do we get to this place of polarization? What do our political institutions look like? Why is it so hard for Congress to do anything, including about the Equal Rights Amendment? What's going on with state legislatures? Do they actually represent the people? I think political scientists are showing that 90% of state legislative seats are not competitive. I think most people can't even name their representative in Congress, and certainly not their representative in their state legislatures. So the mostly conservative Republican-dominated state legislatures that we have may not actually be representative of the American people. People are also very disengaged. So there are a lot of reasons that I think our politics may not be a good way of making the kinds of compromises or even really channeling a conversation that tracks the right way of thinking about patriarchy, feminism, all of these substantive themes. So that's why I think it is important for us to think more procedurally about the political process and our democracy and the way that we've structured it, if we're going to be able, in a position where we could, in good faith, have conversations across disagreement on the substantive issues having to do with gender or race or anything else.
Right. So, well, I don't think that's depressing enough. So why don't we conclude with...
well, it's not. I think there's a lot we can do on there.
Okay, I'm sorry. I do think you're probably an optimist.
I am.
Yes. So I want to say a couple more things, and then we'll wrap up. I know we're detaining you. This has been great, though. It's a fascinating conversation. The book does end up talking about processes of constitutional change, and you get a rich sense of how other countries have more democratic, complicated, iterative, but probably more democratic processes of hashing out fundamental issues and even dealing with constitutional change compared to the United States, and how very broken the U.S. system is in these senses. So we're sort of blocked with the Senate, the non-representational character of legislative bodies with gerrymandering, and so on and so forth. It was fascinating to read about other countries where citizens' commissions or committees are mobilized, or citizens' assemblies. They don't have lawmaking power, but they come together, they talk, and they can issue reports and advise on things. But we're stuck with our broken processes of hashing out these issues. So I take it, there's a lot of interesting stuff we haven't been able to touch on. I guess I want to do 2 points. This point, and this has led you now to your next project, is going to be about our structures, for dealing with our structures, right? The paradox of trying to change structural problems through a structure that's defective and won't allow you to really get anywhere. So I don't know, maybe you want to talk about that for a second, and then I wanted to ask you about whether honoring motherhood is kind of a way into the kinds of conversations you want to have. I think a lot of feminists would find that controversial,
Sure.
Okay, so go ahead, do those 2 things, and then we'll be informed. We'll go upstairs and continue the conversation. There's a very nice reception upstairs. I hope you'll all join us. There'll be some food and drink, and we'll continue to talk for 20 or 30 minutes up there. So take us home.
Okay, so one of the problems is that we have not gotten an infrastructure that actually supports the transition from patriarchy to a gender-equal society, because courts can only do so much, and we haven't had legislatures that have been funding and building child care centers and or parental leave on a national scale. We have a few states that have trickled since the 1990s or so to create paid parental leave. But I think of kind of paid leave, or even if you think about something that I think should be a no-brainer, pregnant worker fairness. It is kind of interesting how much of a struggle it was, how it was filibustered in the Senate, and it eventually got added at the last minute to an appropriations bill. But pregnant workers fairness, the idea that if you're pregnant in the workplace, you should be entitled to an accommodation so that you should carry a water bottle if you need one while you're pregnant and working at a Walmart right? But like, why is that such a struggle for our politics? And interestingly, too, this was an issue where I think, in some ways, the political fight, even at the 11th hour, which made it like possible that it wasn't going to get passed, was that the right wing was really interested in saying, oh, well, we want a carve-out that says that you can't use pregnant worker accommodation to go get an abortion, even though it was very unlikely that it was going to be used that way. But if it was so unlikely that it was going to be used that way, the people who were really in favor of feminism were willing to just let it drop because of that. And that's an issue of this kind of stalemate and polarization that you see in our politics. But if courts can only do so much, maybe we really need to start thinking about restructuring our political institutions. So how are ways that we can make Congress actually more representative and more responsive? Part of the story is doing something about partisan gerrymandering. Another part, I'm arguing also that we need an alternative constitutional voice so that Congress can actually push back against the Supreme Court more often than it does and restore its role as a constitutional lawmaker and constitutional interpreter. So that's the subject of my next book. Another book project that I have beyond that is really looking at how can we revive the constitutional amendment process, because we have notoriously one of the most difficult, and I would say one of the most undemocratic amendment processes in the world. The people have no control over constitutional amendments at the federal level. You need both houses of Congress to adopt it, and then usually 3/4 of state legislatures to ratify it. That's very different from most of the states that involve people ratifying constitutional amendments at the state level through a referendum. There's also the possibility at the state level of using citizen-initiated petitions to put something on the ballot for a referendum. In many countries around the world, including Ireland, you don't get a constitutional amendment without a referendum. In France, they became the first country in the world after this book was published to recognize the guaranteed freedom of voluntary abortion in the French Constitution, March 2024. And that's also like, they didn't have a referendum on that, although referendum is one way that you could amend the Constitution in France. But they have 3/5 of both houses of their parliament, but 3/5 of the whole, not 2/3 of each, right? So if you imagine like even 2/3 of the House and the Senate sitting in a plenary session, that would change things. So I think we need to be a little bit more imaginative about how to change some of the political institutions that seem to be not responsive to the people. That not responsive to the people ends up distorting our politics so that a polarization that doesn't actually represent who most of this country, who we are, ends up taking over. And then we have courts trying to do more than they actually can, and then a backlash against that. So I think in the future, we like to get past it. I think we need to be more imaginative about reworking the institutions that we have and then finding ways of amending them in the future.
Okay, thanks. I'm going to open it up for a few questions. Okay, so we'll do that. Let's put a paperclip in the motherhood question. So I'll ask it from the floor if there's time. So who would like to ask a question? Okay. You could state your name and ask your question.
Hi, my name is Sabil. I'm a journalism student. And what you said earlier about the reason women don't have rights is because women are society's plan to reproduce itself, that really stood out to me. And you had mentioned earlier that you were born in Seoul, South Korea, and one of the feminist movements in Korea, the 4B movement, where women have taken the approach to not be involved with men at all, including not dating, not marrying, or bearing their children. Do you think a movement like this is effective in bringing women closer to gender equality, or is the approach too extreme?
So I don't know if it's even a strategy. I think it's just if the government is not going to make it possible to do anything other than fall back into a soft coercion of very limited roles as humans, as child bearer and child rearer, then it may not even be a strategy. It might just be if the choices are, I could bear and raise children, or I could do other things. So one of my responses is that it might actually be a very rational response. And certainly before women are fully included in suffrage and economic rights in the United States, there are a lot of women in the 19th century, and like interesting literature, who choose not to marry or have children because it is possible in some limited ways, not equality, but it is possible even in the 19th century for women to do other things as long as they don't marry. It was really only married women who lost their property rights under patriarchal legal regimes. The other thing I'll mention is that in Ireland in the 1970s, there's a women's strike, like a day in which women just walk out of their jobs and do zero childcare or housework. That idea was also really central to the Women's Strike for Equality in 1970, which was on Women's Equality Day. This was like the 50th anniversary of women's suffrage in the United States, of the 19th Amendment's ratification. There's the Women's Strike for Equality, and it was just protests in every city, but the premise of it was to just not do any kind of traditional patriarchal labor that was expected. And I think that premise, not just a women's march, but the idea of a strike, refusing to do the things that are taken for granted, I think that has been a powerful symbolic move. The Women's Strike for Equality was really important, I think, in mobilizing more and moving ahead the movement for the Equal Rights Amendment in the United States, which then, was voted in Congress in August of 1970, and eventually, even though it didn't quite succeed in Congress in the first time in 1970-71, without the Women's Strike for Equality, I don't think it would have succeeded in 1972 when it does succeed and get sent to the states for ratification.
Hi, my name's Maria. I've been thinking a lot about maternal mortality in the U.S. Isn't just a health issue. It's also tied to systemic racism and what feels like a form of medical misogyny, especially when Black women are over 3 times more likely to die during pregnancy or childbirth, even when they have similar resources. And it makes me think about Ruth Bader Ginsburg's how she spoke about equality not just being completely colorblind or gender blind, but recognizing that sometimes women and people of color need more intentional support to actually reach equal outcomes for generations of inequality. So I'm wondering how you see the law either contributing to or potentially fixing that disparity, especially since these outcomes seem driven by structural racism and misogyny rather than just gaps in access.
So I think maternal mortality, and especially the racial disparities in maternal mortality, are just another indication of what I'm calling structural misogyny in the book, which is the expectation that women just do all these things, bear children, risk their lives so that children can be gestated and born, even if it costs the woman her life. And so I think that the maternal mortality is an indication of that structural misogyny, as I describe it. And I think it can be it should be a salient and useful data point. So one of the things we didn't get into in this conversation is you could just ask then, given that now we have all these abortion bans that are no longer made illegal by Roe v. Wade after Dobbs, do we have other ways of challenging abortion bans that many of the states, and some of them are quite draconian. The only exception for the abortion ban is if the woman's life is imminently in danger. But one of the arguments that I make, and it's not like we'll succeed with flying colors if we try it before a judge tomorrow kind of argument. But one of the arguments that I make in the book is that we should try to think of the abortion ban through the lens of takings, which is a doctrine in US constitutional law that says that if the government takes your property, it owes you just compensation. And so I think that if we think of the abortion ban as the state renting women's wombs without just compensation, that might be a useful frame for thinking of what is the problem with banning abortion. They're not giving you a choice. They're forcing you to gestate babies. Even if you decide not to raise the child or give it up for adoption, they're forcing you to gestate a baby without just compensation. And I also think that if we try to think of what's wrong with the abortion ban is that extraction or that expectation of reproductive work without properly valuing it. You might also say that especially in states that have high rates of maternal mortality, and especially high rates of maternal mortality against Black women who are doubly undervalued or disvalued, though that's an indication that whatever pro-life justification is given for protecting the fetus through an abortion ban should not be taken as a good faith justification. How could you be pro-life if women are dying to allow children to be born to the society's benefit?
And, okay, so I wanted to follow up on this. I hope to get to it. The takings clause argument is quite fascinating. It seems to be a way of calling out the government and saying, well, if you're going to force it, you should pay for it. And I found myself imagining like what my price would be for carrying an unwanted pregnancy. I would say something like $20,000 a day. Interesting idea. It's still monstrous to coerce it even if you pay for it, but now we're coercing it and we're not compensating it. But you also mentioned the 13th Amendment, and I wanted to ask you, like, why not? Does the Equal Protection Clause argument simply reintroduce some of the problems you've developed? The 13th Amendment has been invoked. I think that's a fascinating argument. None of these arguments have power tomorrow, like you said, but all legal doctrines start somewhere, right? So
Yeah.
if you want to just follow up on that, I mean, I think it's fascinating.
So-
There's a lot of great stuff in this book, folks. I mean, I didn't get to half of it, so.
So I think there are a lot of ideas that come from constitutional doctrine, and some of the best ideas in constitutional doctrine, unfortunately, are not arguments that will persuade the people who are sitting on the Supreme Court or other federal courts right now. But that said, I think the arguments are useful as frames for thinking about what the problem is, and to the extent that part of my project is to encourage people not only to think about arguments that will persuade courts, but arguments that make sense in terms of trying to reimagine the places of power where you might actually be able to affect policy change. We should try to think of these arguments as persuasive ones to develop. So absolutely, and this is not original to me. I think feminists, since even before Roe, thought of abortion bans or the regulation of abortion through the lens of the 13th Amendment. And there's some interesting work suggesting that abolition, like even during the time that the 13th Amendment was framed and imagined and adopted, if you want to be an originalist about public meaning, that certainly the systemic rape of enslaved women by slaveholders, especially after, so in the US Constitution, we couldn't ban the slave trade until 1808. That was made an unamendable part of the US Constitution at the founding. But once Congress banned the slave trade after that, then the way that slaves were reproduced, or slavery was reproduced and didn't just die out, was the systemic rape of enslaved women. So you could think of there being like a very strong originalist understanding that the systemic coerced motherhood that's racialized is exactly the kind of thing that the 13th Amendment, among other things, but that is like, it's not a stretch to say that the 13th Amendment bans coerced motherhood. But I don't know that that's going to persuade even a carefully selected court to which to make that argument today, even though I think it is a very compelling one. And similarly, I think a compelling argument could be made on the takings clause. And I think the takings argument is interesting because now another axis of contrast between the United States and many European countries with regard to motherhood is commercial surrogacy. Many European countries ban or severely restrict surrogacy and specifically ban commercial surrogacy. Whereas, interestingly, because the United States has so much commercial surrogacy, it's not hard to calculate in monetary terms, at least the gestation part, even though surrogacy arrangements are chosen and are contractual. But here, if you had an abortion ban and then you were going to challenge the abortion ban, or not just challenge it to get it struck down, but demand compensation because of my state's abortion ban, I was coerced into gestating a child for the benefit of others, and therefore I'm owed, and you can like use math based on surrogacy contracts to determine what the damages would be. I don't know. I mean, I think people probably find that argument very disturbing. This idea that the state can extract that kind of coercion of the body as long as it's willing to pay the price. I guess I'm not totally in favor of it on the one hand, but on the other hand, I don't think it's a stretch to say that in political theory, or as long as we've had states, one of the things that they do is they conscript men for military service, and they control men's bodies for the public benefit through military service. And I'm not in favor of the draft, really. But if you think that it is part of what a state does, which is to draft men and control their bodies to defend the nation, then they are, of course, compensated. And so you could use that analogy. And that's also not original to me, I think. Many people have like drawn the soldiers and mothers comparison. But if you think that conscription of soldiers are okay, you might get to a place where you think that conscripted motherhood may or may not be okay, but if it's going to happen, it should definitely be compensated.
Yeah, sure. Okay, so I think that's a good place. One more. Hi. How you doing, Jackie?
Good evening. My name is Jackie Burks. I'm a political science major. Thank you for being here with us and giving us some inspiration. I have a question. Were there particular experiences that encouraged you to focus your work on supporting women through law?
So, wow. So we're going to have to be here for another couple hours. Okay. So I guess the answer is yes. And I think certainly just growing up, and I'll just say one thing, which might strike you as weird. I did mention earlier in the hour that I grew up playing the violin. And one thing that never occurred to me, I played in orchestras all the time, it never occurred to me to take conducting lessons, although one of the things I really love is like orchestral music, symphonies. And I think it's because I never saw a female conductor. like never, was never, like just like a concept. And that is one of the professions, like obviously like people in the 19th century, like women couldn't be lawyers. But it's amazing to me how, like, growing up, you also think that you live in a gender equal society, and I think I largely did. I did not grow up thinking, like, everyone was misogynist and all these doors were closed to me. But it is interesting, like, so much of, it's like you sort of reflect on the choices that you make later, and you're like, oh, wow, some of these choices were structured without my even knowing it. And I think it was that process of kind of growing up and learning more about the world that led me eventually to focus on women and gender equality.
Okay, please join me in thanking our guest, Professor Julie Sook. Fascinating book, great conversation. Okay, so please join us. Go out, go up the stairs, find the food and drink, hang out. Professor Sook will be joining us up there for a few minutes, at least 10 or 15 minutes. And thank you. Also, is the clue sheet